या कार्यक्रमासाठी माननीय के शिंदे साहेब, न्यायमूर्ती उच्च न्यायालय मुंबई यांना मी विनंती करतो की आपण व्यासपीठावर स्थानापन्न व्हावे. तसेच माननीय पी नांदेडकर साहेब यांना मी विनंती करतो की आपण व्यासपीठावर स्थानापन्न व्हावे. सर्व वकील बांधवांना विनंती आहे भगिनींनी की आपण खुर्चींवरती बसून घ्यावे. आज दिनांक 19 नोव्हेंबर जागतिक पुरुष दिन. जागतिक पुरुष दिनाच्या सर्वांना खूप खूप शुभेच्छा. माननीय के शिंदे साहेब, न्यायमूर्ती उच्च न्यायालय मुंबई यांचे पुणे बार असोसिएशनच्या वतीने मी मनपूर्वक असे स्वागत करतो. तसेच माननीय पी नांदेडकर साहेब, जिल्हा व सत्र न्यायाधीश क्रमांक 1 यांचेही मी पुणे बार असोसिएशनच्या वतीने मनस्वी असे स्वागत करतो. तसेच उपस्थित पुणे जिल्हा न्यायालयातील न्यायाधीश यांचे देखील मी मनपूर्वक स्वागत करतो. तसेच या कार्यक्रमासाठी उपस्थित सर्व सिनियर्स, वकील बंधू भगिनींनी यांचे देखील मी पुणे बार असोसिएशनच्या वतीने स्वागत करतो. पुणे जिल्हा न्यायालयात अशोक हॉल गेली 20 वर्षांनंतर रिन्युएट करण्यात आला. त्यासाठी पुणे बार असोसिएशनचे अध्यक्ष ॲडव्होकेट पांडुरंग थोरवे सर व आम्ही सर्व कमिटीने तसा प्रस्ताव माननीय प्रमुख जिल्हा न्यायाधीश सी चांडक साहेबांना दिला. त्यावरती साहेबांनी तात्काळ होकार दर्शवून आपल्या जिल्हा न्यायालयातील न्यायाधीश पी नांदेडकर साहेब यांची नेमणूक केली व त्यांच्या मार्गदर्शनाखाली अशोक हॉलचे काम करण्याचे ठरले. सदरील कामकाज करताना नांदेडकर साहेबांनी वैयक्तिकरित्या त्यांच्या व्यस्त दिनचर्येतून सकाळी आल्यावर असू, दुपारी लंचच्या टायमिंगमध्ये असू, 5 वाजता असू, काम झाल्यानंतर असू, साहेबांनी वैयक्तिकरित्या थांबून सर्व कामाची पाहणी केली, वेळोवेळी योग्य त्या सूचना दिल्या व सदरील काम हे 5 ते 7 दिवसात पूर्ण झाले. आणि आजच्या कार्यक्रमासाठी अशोक हॉल उपलब्ध होणे, वेळेत उपलब्ध होणे हे आमच्या सर्वांपुढे एक आव्हान होतं आणि ते आव्हान आम्ही बऱ्यापैकी पेललेलं आहे. थोडंसं काम राहिलेलं आहे पण ते येणाऱ्या 2 दिवसात ते काम होऊन जाईल. त्यासाठी पुणे बार असोसिएशनचे अध्यक्ष ॲडव्होकेट पांडुरंग थोरवे सर, उपाध्यक्ष ॲडव्होकेट विवेक बरगुडे सर, मी अमोल शितोळे, रितेश पाटील, कोर्ट नाझर सुभाष गायकवाड साहेब, दिलीप करंबेकर नाझर, शिपाई संजय डोईफोडे, कोर्ट स्टाफ, PWD, ज्ञात अज्ञात कर्मचारी, कामगार यांनी सहकार्य केले. रात्री 11:30-12 वाजले तोपर्यंत सर्व ही मंडळी इथं उपस्थित होती आणि हे काम पूर्ण करून घेतलं. त्याबद्दल मी सर्वांचे खूप खूप आभार व्यक्त करतो. आणि सदरचं रिन्युएशन हे आमच्या कारकिर्दीत पूर्ण झालेलं आहे याचा आम्हाला आनंद आहे. यासाठी पुणे बार असोसिएशन आपल्या सर्वांचे शतशः आभारी आहे. आपल्या बारचे लाडके अध्यक्ष ॲडव्होकेट पांडुरंग थोरवे सर यांना सरन्यायाधीश सर्वोच्च न्यायालय दिल्ली माननीय धनंजय चंद्रचूड साहेब यांनी आज भेटण्याची वेळ दिली होती आणि सरांना रात्री तो उशिरा निरोप मिळाला, त्यामुळे सरांना दिल्लीला जावे लागले. त्यामुळे सर आज कार्यक्रमास उपस्थित राहू शकले नाहीत. त्यांच्या वतीने मी पुणे बार असोसिएशनचे उपाध्यक्ष ॲडव्होकेट विवेक बरगुडे सर यांना मी विनंती करतो की माननीय न्यायमूर्ती के शिंदे साहेब यांचा आपण सन्मान करावा. पुढील सन्मान आपल्या पुणे जिल्हा व सत्र न्यायालयातील न्यायाधीश के.पी. नांदेडकर साहेब यांचा करण्यात येत आहे. मी पुणे बार असोसिएशनचे उपाध्यक्ष लक्ष्मणराव वेळे पाटील यांना विनंती करतो की आपण साहेबांचा सन्मान करावा. धन्यवाद साहेब. पुढील कार्यक्रमाकडे वळताना मी आपले पुणे बार असोसिएशनचे उपाध्यक्ष ॲडव्होकेट विवेक बोरगुडे सरांना मी विनंती करतो की आजच्या आपल्या कार्यक्रमाचे सन्माननीय प्रमुख पाहुणे माननीय न्यायमूर्ती एस के शिंदे साहेब यांचा परिचय करावा व कार्यक्रमाची प्रस्तावना करावी.
नमस्कार. व्यासपीठावर उपस्थित माननीय न्यायमूर्ती श्री संदीपजी शिंदे साहेब, उच्च न्यायालय मुंबई, के.पी. नांदेडकर सर, जिल्हा न्यायाधीश पुणे, तसेच व्यासपीठासमोरील सन्माननीय न्यायाधीश तसेच सर्व सिनियर्स ज्युनियर्स ॲडव्होकेट्स यांचे मी प्रथम पुणे बार असोसिएशनच्या वतीने स्वागत करत आहे. आजचा कार्यक्रम हा ज्युडिशियल कोलकिया पुष्प 6 या अंतर्गत माननीय न्यायमूर्ती श्री संदीप शिंदे साहेब यांचे प्रिझम्पशन इन क्रिमिनल ट्रायल या विषयावर ते आपणास मार्गदर्शन करणार आहेत. ज्युडिशियल कोलकिया या नावाने आपण एक लेक्चर सिरीज पुणे बार असोसिएशननी आयोजित केली. यामध्ये सर्वोच्च न्यायालय व उच्च न्यायालयाचे येथील न्यायमूर्ती तसेच ज्येष्ठ विधितज्ञ हे आपल्या बारमध्ये सर्व वकील बंधू भगिनींना मार्गदर्शन करत असतात. ज्युडिशियल कोलकिया या संकल्पनेचा शुभारंभ सर्वोच्च न्यायालयाचे न्यायमूर्ती जस्टिस पी.एस. नरसिंहा साहेब यांच्या हस्ते झालेलं आहे. दुसरे पुष्प आपले न्यायमूर्ती संदीपजी मारणे साहेब यांनी आपल्याला मार्गदर्शन केले. तिसऱ्या पुष्पामध्ये न्यायमूर्ती श्रीराम मोडक साहेब यांनी आपल्याकडं मार्गदर्शन केले. चौथे पुष्प न्यायमूर्ती मृदुला बाटकर मॅडम यांनी आपल्याला मार्गदर्शन केले. आणि पाचवे पुष्प न्यायमूर्ती जस्टिस सानप साहेब यांनी आपल्याला मार्गदर्शन केले. आणि आजच्या 6व्या चॅप्टर 6ला न्यायमूर्ती संदीपजी शिंदे साहेब यांनी आपल्याला वेळ दिला. सर्वप्रथम मी पुणे बार असोसिएशनतर्फे पुन्हा एकदा त्यांचं स्वागत व आभार मानतो. आणि त्यांचा परिचय मी आपल्यापुढे देतो. पूर्ण नाव संदीप काशीनाथ शिंदे साहेब, जन्मदिन 17 जानेवारी 1961, जन्मठिकाण कल्याण ठाणे, शिक्षण BCom LLM इन 1988 to 89. त्यांनी ट्रायल कोर्टामध्ये काम केले आणि हायकोर्टामध्येही काम केलेले आहेत. न्यायमूर्तींनी मुंबई हायकोर्ट सिनियर ॲडव्होकेट अशोक मुंदरके सर यांच्याकडे काम बघितले. 1997 ते 98मध्ये त्यांची असिस्टंट गव्हर्नमेंट लीडर स्टेट ऑफ महाराष्ट्र इन रिटसेल म्हणून नेमणूक झाली. त्यांनी त्यामध्ये एज्युकेशन, इलेक्शन अँड लँड ॲक्विजिशनचे काम पाहिले. डिसेंबर 2006मध्ये त्यांनी जिल्हा न्यायाधीश नाशिक, मालेगाव, ठाणे, अलिबाग येथे नियुक्ती झाली. जॉईंट सेक्रेटरी कम सॉलिसिटर इन लॉ ज्युडिशियल मंत्रालय म्हणूनही त्यांनी काम पाहिले. काही कारणास्तव पदाचा राजीनामा दिला व 2007 व 8 साली त्यांनी वकिली पुन्हा एकदा हायकोर्टामध्ये चालू केली. 2007-8मध्ये त्यांची गव्हर्नमेंट लीडर रिटसेल आणि पब्लिक प्रॉसिक्युटर म्हणून नियुक्ती झाली. त्यांनी युनियन ऑफ इंडिया, CBI, मिनिस्ट्री ऑफ डिफेन्स अशा विविध क्रिमिनल मॅटरमध्ये काम पाहिले. जून 2017 साली त्यांच्या हायकोर्ट म्हणून पुन्हा एकदा नियुक्ती झाली. न्यायमूर्ती संदीप शिंदे सर यांनी दिल्ली सर्वोच्च न्यायालयाचे न्यायमूर्ती व्हावे ही संपूर्ण पुणे बार असोसिएशनच्या वतीने मी सदिच्छा व शुभेच्छा देतो आणि थांबतो. जय हिंद, जय महाराष्ट्र.
धन्यवाद. मी आपल्या जिल्हा न्यायालयातील माननीय के.पी. नांदेडकर साहेब, जिल्हा व सत्र न्यायाधीश क्रमांक 1 यांना मी विनंती करतो की साहेबांनी आपलं मनोगत व्यक्त करावं.
नमस्कार. आदरणीय न्यायमूर्ती श्रीमान शिंदे सर, आपल्या वकील संघाचे उपाध्यक्ष, सर्व सन्माननीय पदाधिकारी, अशोका हॉलमध्ये उपस्थित असलेले सर्व ज्येष्ठ विधिज्ञ, माझे सर्व सहकारी न्यायाधीश बंधू भगिनी आणि उपस्थित सर्व विधिज्ञ बंधू भगिनींनी, जीवनाच्या कालप्रवाहामध्ये सतत बदल होत असतात. परिस्थितीनुरूप खूप जीवनामध्ये बदल होत असतात. अगदी साधं उदाहरण द्यायचं तर मागच्या 2 वर्षामध्ये आपण कोरोनाच्या कालावधीमध्ये आपण पाहिलं की जीवन अगदी पूर्णपणे बदललेलं होतं. प्राप्त परिस्थितीनुसार मग ज्ञानाच्या शाखाही बदलतात. आपण कोरोनामध्ये पाहिलं असेल, बाकी सगळं संशोधन थांबलेलं होतं आणि आपण फक्त कोरोनावरच्या औषधाच्या संशोधनाच्या मागे लागलेलो होतो. प्राप्त परिस्थितीनुसार असे बदल हे समाजामध्ये हे कायम होत असतात. जीवनाच्या प्रत्येक क्षेत्रामध्ये बदल हे होतच असतात आणि सतत प्रवाही असेल तेच जीवन हे खरं जीवन आहे असं मला व्यक्तिशः वाटतं. अशा बदलणाऱ्या परिस्थितीमध्ये मी म्हणालो तसं सगळ्या ज्ञानाच्या शाखांच्यामध्ये वेळोवेळी बदल होतात. आपण पाहिलं असेल तर मागच्या 50-100 वर्षामध्ये अभियांत्रिकी शाखेमध्ये जे काही बदल झाले, अभियांत्रिकी ज्ञानामध्ये जे बदल झाले, 1980च्या नंतर जे कॉम्प्युटरचं युग आलं, संगणकीय युग आलं आणि मग माध्यम क्षेत्रामध्ये जी क्रांती झाली आणि त्या क्षेत्रातलं जे संशोधन झालं, त्या क्षेत्रामधले जे बदल झाले, त्यानिमित्ताने काही कायदे निर्माण झाले. वैद्यकीय क्षेत्रामध्ये जे बदल झाले त्यानिमित्ताने काही कायदे निर्माण झाले. ग्राहकांच्या चळवळीच्या निमित्ताने काही कायदे निर्माण झाले. भौगोलिक परिस्थितीनुसार दररोज कायदे मंचामध्ये बदल होतात. पार्लमेंटकडून तर कायदा तयार केलाच जातो, परंतु माननीय सर्वोच्च न्यायालय आणि माननीय उच्च न्यायालयांच्याकडून सुद्धा न्यायनिवाड यांच्याद्वारे कायद्यांना नवीन आयाम दिले जातात. म्हणजे हे ज्ञानाचं क्षेत्र हे अथांग सागरासारखं आहे आणि या प्राप्त परिस्थितीमध्ये सतत होणाऱ्या बदलांच्या मध्ये आपण जर अपडेट राहिलं नाही तर कदाचित आपण कालप्रवाहापासून पतित होण्याची किंवा पाठीमागे जाण्याची शक्यता असते. म्हणून ज्ञानाच्या क्षेत्रामध्ये अपडेट होणं हे अत्यंत गरजेचं आहे. ही सगळी सिनियर मंडळी जी समोर बसलेली आहेत, मला आठवतं माझेही सिनियर दररोज त्या काळामध्ये महाराष्ट्र लॉ जर्नल असेल, AIR असेल, हे दररोज वाचल्याशिवाय ते झोपायचे नाहीत. ते जे वाचन जे होतं ते वाचन म्हणजे अपडेटिंग होतं रोजचं. आता अपडेटिंगची थोडी पद्धत बदललेली आहे. सोशल मीडियामुळं आणि संगणकीय तंत्रज्ञानामुळं आता एव्हरीथिंग इज अवेलेबल ॲट द टिप ऑफ फिंगर आपल्या. तर त्याच्यामुळे काय झालं की आपण जी पूर्वीची पुस्तक वाचायची ती सवय आपली बरीचशी नव्या पिढीच्यामध्ये मोडलेली असेल असं मला वाटतं. कारण 138 NI ॲक्ट म्हटलं की जो भराभर केस लॉ येतो तो पूर्ण वाचायचा की नाही वाचायचा, का फक्त आपल्याला पाहिजे तेवढे 2 प्रिंट काढायच्या आणि कोर्टात नेऊन टाकायच्या, हा जो काही प्रकार चाललेला आहे ना, मला वाटतं ज्ञानाला आपण अपडेट करण्यासाठी वाचन केलं पाहिजे. आणि अपडेट होताना जर अशा आदरणीय न्यायमूर्तींचं मार्गदर्शन आपल्याला लाभलं आणि खरोखर वक्ता दस सहस्त्रेषु असं म्हणतात, 10,000च्या मध्ये एखादा वक्ता असा असतो की जो त्यांच्या मनातले विचार, त्या वक्त्याच्या मनातले विचार श्रोत्यांच्या कानात नव्हे मनामध्ये आणि बुद्धीवर त्याचा ठसा उमटवतात. असे 10,000मधून एखादा वक्ता असू शकतो. मला विशेष आनंद होतो आहे की मला सकाळी माझ्या एका मित्राचा फोन आला आणि मी आदरणीय न्यायमूर्तींनाही सांगितलं की मला विशेष आनंद झाला. मी म्हटलं लॉर्डशिप आज इथे येत आहेत आणि आमच्या वकील संघाच्या ज्युडिशियल कोलोकियामध्ये लॉर्डशिपचं मार्गदर्शन आहे. तर तो माझा मित्र मला म्हणाला, यू आर लकी इनफ आणि संधी चुकवू नकोस. मग इतकं जेव्हा आपण चांगलं आणि ज्ञानी माणसाचे विषय ऐकतो तेव्हा मनामध्ये उत्सुकता अजून जास्त निर्माण होते की आपल्या ज्ञानामध्ये आज खूप भर पडणार आहे आणि आपणही चांगल्या पद्धतीने अपडेट होण्याची चांगली संधी आहे. वकील संघाने ही खूप चांगली संधी तुमच्या सर्वांच्यासोबत आम्हालाही उपलब्ध करून दिली, त्याबद्दल वकील संघाचे मानावे तेवढे आभार कमीच आहेत. खरं म्हटलं तर आदरणीय चांडक सर या कार्यक्रमाला उपस्थित राहायला हवे होते, परंतु 3 आपले गार्डियन जजेस, आपले पालक न्यायमूर्ती पुणे जिल्ह्यात आहेत. आदरणीय चांडक सर तिकडे आहेत त्यांच्यासोबत, म्हणून माझ्यावर फार मोठी जबाबदारी वकील संघाने आज या ठिकाणी टाकली आणि मला इथे बसण्याची संधी दिली. सर्वात शेवटी जाता जाता उल्लेख एका गोष्टीचा करतो की अशोका हॉलचं हे रंगरंगोटी झाल्यानंतर, रिनोव्हेशन झाल्यानंतरचं हे पहिलं फंक्शन आहे आणि त्या पहिल्या फंक्शनमध्ये मला या व्यासपीठावर बसण्याचा मान मिळतो आहे. हे माझ्यासाठी महत्भाग्याचा क्षण आहे. मला कल्पना आहे आदरणीय न्यायमूर्तींचे विचार ऐकण्यासाठी आपण सर्वजण उत्सुक आहोत, म्हणून मी माझं भाषण या ठिकाणी थांबवतो. मला उपस्थित राहण्याची संधी दिल्याबद्दल वकील संघाचे मनपूर्वक आभार मानतो. माझ्या सहकारी न्यायाधीश बांधवांना सुचवू इच्छितो, आदरणीय न्यायमूर्तींनी सूचना दिलेली की 2:45 नंतर आपली प्रत्येकाची जबाबदारी आपापल्या न्यायासनावर जाण्याची आहे, त्याच्याकडे आपण लक्ष द्यावं. मी या ठिकाणी थांबतो. धन्यवाद. जय हिंद, जय महाराष्ट्र.
धन्यवाद साहेब. आज या बिल्डिंगच्या पायाभरणीला 22 नोव्हेंबरला 100 वर्ष पूर्ण होत आहेत. त्याचंच औचित्य साधून आपल्या मार्गदर्शनाखाली हे काम करण्यात आलं आणि काम छान झालं असं आम्हाला पण वाटतंय साहेब. त्याबद्दल आपण केलेल्या मार्गदर्शनाबद्दल खूप खूप धन्यवाद. आपण ज्यांना ऐकण्यासाठी आज या ठिकाणी उपस्थित आहोत असे माननीय न्यायमूर्ती SK शिंदे साहेब, मी साहेबांना विनंती करतो की आज आपण उपस्थित वकील वर्गांना मार्गदर्शन करावे.
माननीय जिल्हा न्यायाधीश श्री KP नांदेडकर, सन्माननीय व्यासपीठ, उपस्थित न्यायमूर्ती, उपस्थित संपूर्ण वकील वर्ग, सिनियर ॲडव्होकेट श्री दिघे, माझ्या परिचयाचे भगवानराव साळुंखे, सर्व ज्युनियर आणि सिनियर्स लॉयर्स आणि सर्व बार असोसिएशनच्या पदाधिकाऱ्यांचं मी प्रथम आभार मानतो की त्यांनी मला इथे बोलवून माझा सत्कार केला आणि काही शब्द किंवा माझं काही मतं मांडण्यासाठी जे व्यासपीठ उपलब्ध करून दिलं त्याबद्दल मी त्यांचा आभारी आहे. खूपसा तुमचा वेळ घेत नाही आणि असलेल्या विषयाकडे मला वाटतं की आपण सुरुवात करावी. The subject which has been allotted to me, or the subject which has been stated on which I am supposed to deliver my thoughts or say something on the issue, that relates to the discharge of burden. And I am likely to decided to speak on the interpretation of the reverse onus clauses in the special enactment with special reference to the criminal jurisprudence. As Mr. Nandedkar has in his opening speech, and in the introductory speech he spoke that the new laws are coming nowadays. Every day we find a new legislation comes. There is a demand from the public that a particular menace in the society is required to be arrested, to be regulated, and therefore a new piece of legislation takes birth. Now there are n number of legislations, acts in the place, pre-independence, post-independence. And obviously, as a traditional law says, as the Evidence Act itself says, which has been interpreted for the centuries, the prosecution is given a task to discharge the burden. So one who makes an allegation, one who comes to the court, his primary duty to prove a fact or to prove the charge or to prove the issues and his own case. Now, since subject I have restricted to a criminal jurisprudence with a reference to the special enactments. Nowadays, you can see now, it's a very popular say, the law does not become a tool for operation. Justice Chandrachud recently said this, that the law does not become a tool for operation, but remains instrument of a justice. Well, this has different facets, and we'll try to explore it as to in one context. The speech was delivered by Justice Dr. Chandrachud. Now, we all know that the burden of proof lies upon a person who has to prove the fact. There is a difference between the onus and the burden of proof. A long case of Chechenna in 1964 has explained the facets and the niceties. What do you mean by the burden? And what is an onus? In Marathi, we can call, in a simple language, that the burden is a ojha and the onus is a jababdari. So we'll try to explore the subject from this context. Now, the discharge of burden or the prosecution discharges burdens, what is the philosophy behind it? A philosophy behind this in the criminal jurisprudence is, as we know, that on every accused is innocent unless his guilt is proven. So therefore, there is intrinsic link between the presumption of an innocence. He has to be treated as an innocent for what? He is to be treated as an innocent because that will inculcate a faith in the system. Why a discharge is to be burdened by the prosecution and why a discharge is not to be, a burden is not to be discharged by the accused? Have you ever thought of it? The reason being is this, that allowing a guilty to go free is better than convicting the innocent. So, to have a faith in the society, to have a faith in the system, we always believe that the person who makes an allegation has to discharge the burden. If the position is a reverse, if the person is arrested and if he is asked to discharge the burden to prove that you are the innocent, so he has to disprove that he has not committed the crime. Well, that will be a negative burden. A negative burden is a fact which does not exist. So the fact which does not exist is very difficult to prove. Therefore, you will find always a charge or an issue in the civil courts are in the positive issues. Whether plaintiff proves that the defendant has encroached over the land. So this is a positive assertion. There is no issue like this whether the defendant disproves. So the burden is on the person who comes to the court with the case against the other side. Now why the only prosecution has to discharge the burden? This would be the question you must ask. Why this is the traditional law of the interpretation evolved for the years, centuries. Now in the criminal jurisprudence you will find the state is always a prosecution agency. The state comes to the court because we consider any offense which is being committed, that offense is against the society at large. And therefore the society and therefore the state, being a parent, always prosecute the wrongdoer. Now the state, when there is a trial, when the trial takes place in the criminal law, there are two actors. One actor is the state and another actor is an accused. Obviously, you will find these two actors are unequal. one has a tremendous resources in its hands, whereas the accused is without any resources. So take an example or an illustration. If the accused is asked to disprove the case of the prosecution, who is not armed with any resources, whereas a state is equipped and have the resources so much, or they have an access to the resources by which they will be able to collect the evidence and put it before the court. Now, therefore, this being the two different or the two players in the trial with the unequal footings, a more burden is cast on a person or a state to prove its case. So, therefore, we say that a prosecution has to discharge the burden. If the position is taken otherwise, then the condition would be this, that the person, once he becomes an accused or once the offense is registered, then he has to prove that he is not guilty. So there will be the presumptive culpability, or there will be a presumptive conviction unless and until that conviction or that guilt has been disproved by him. Now, in so far as any offense under the IPC or the special law, if you take into consideration, you will find that any offense or any act alone does not make a person guilty unless he has a guilty mind. So, in any trial, in any criminal trial, there are two sides. One is the actual commission of the offense, which we called the actus reus, and another is called a mens rea. These 2 points, these 2 factors, that is actual occurrence and the mens rea, are required to be proved. If only act is proved without there being any knowledge, without there being any intention, whether we can say that offense has been proved, the answer would be no, as per the traditional law is concerned. Therefore, whenever the offense takes place, the prosecution has to prove a commission and an omission committed by the person which leads to an offense. But at the same time, the prosecution is also required to prove that that offense has been done by an intention or by the knowledge. Well, these are the basic things. Now, if there is no knowledge or if there is no intention, then the offense cannot be said to be proved. So therefore, this has to go hand in hand. But now, so far as the intention is concerned, sometimes we find that it is very difficult to prove the fact which is within the special knowledge of an accused. And therefore, a theory was evolved that such a knowledge or such a intention of a person who committed the crime being within his special knowledge, why the burden should not be shifted on him. Now, thereby you will find the jurisprudence has started shifting slowly, but nevertheless, the legislators had taken the care of this aspect very long back. For an example, we have the section 106 under the Evidence Act, which speaks of the special knowledge of an accused who committed the offense. Now, we have a section 114 of the Evidence Act, where we go on certain presumptions. The first presumption would be a person who was found in a possession of a stolen property has to give an account of it. And therefore, the presumption is that the person who was found in the possession of the stolen property, presumption is that he had a knowledge that this was a stolen property. So obviously there are presumptions of facts and the presumptions in the law, in the Evidence Act itself. And why the presumptions? Why the presumptions takes place? Because presumptions are under proof. Proof is a different. Presumptions are different. The presumptions are required because if you want to prove one fact, and that fact has to be proved with the another fact, and if there is a long gap or there is a much distance between these two facts which you cannot travel, the prosecution finds is not possible to prove or prove to that link, then we evolve the concept like a presumptions. Now you see that, as I said, in the jurisprudence till 2005-2006, if you study critically the judgments or the law which has evolved slowly, the burden of proof or the reverse burden has been taken recourse by the legislators. Why such reverse burdens? Why the accused has been asked to prove that he was an innocent? Why this theory has been evolved by the parliament? What was the reason behind it? You will find the special enactments like a POXO or the NDPS Act or even the Wealth Act, or for that example you will find the Essential Commodities Act. If you certain provisions under these special enactments, if you see the section 10B of the Essential Commodities Act, you will find there is a departure from the traditional law of discharging the burden, where the trader or the license holder who commits the breach of any order on the Commodities Act is presumed that he has committed the offense, and then he has to discharge the burden. So you will find the enactments which has the facet of the socio-economy, which has a larger impact on the society and not an individual restricted or the focused crimes, we see that the burden has started shifting. For example, you take the Wealth Act, you take the POXO, you take the NDPS Act. In all these two acts, at least POXO Act and the NDPS Act, which has been considered offense not an individual intrinsic, but it is a society where the victims are at large. For an example, when a person or a trader sells the narcotic drugs or the psychotropic substance, the victims of his acts, the victims of his omission, is not a single or an individual. The victims are large, read at large. There are societies being largely affected. So the enactments which has a larger repercussion or the effect of any act or omission of an offender, those we call normally a socio-economy legislation. Now over the years of the experience, the Law Commission in its report, 74th or 72nd report, suggested if you have to curtail this menace of the drug trafficking or say the exploitation of the atrocity on the children or the child, we need to have a special legislation. And with this special legislation, we have to see that the burden to discharge a particular the presumption is to be on the accused. So the law, you find the NDPS Act or the POXO Act, these two enactments are largely founded on the presumptions. Now, these presumptions is definitely a departing from the traditional laws or the traditional criminal jurisprudence, because now the burden is shifted on the accused to disprove the particular fact. But now the question always remains, as I said earlier, when I started this lecture, that a person who comes into the court, like a state makes an allegation, because the state is a prosecutor, he dictates the entire trial, he dictates how the charge is to be framed. Then whether there is any possibility by making a person to prove that he was innocent, what will be the repercussions in the society? Is it not possible for the state to target a person, book him for an enactment under the offense of the special law, and then until he disproves that he was not guilty or he was innocent, the presumption is that he has committed an offense. But this completely changes the scenario or the law as we understand or was evolved for the centuries together. Now see the two provisions. I will just read out the two provisions of the POCSO. That could be the section 27 or the 30. These two presumptions, that is section 29 and the section 30. Now before I read these two sections, that is what I interpreted the law, that is what I understood the law. You may have the different perceptions, you may have the different thinking over it, you may argue these provisions in a different manner, but nevertheless, this is what my own perception, that is what I understood from these provisions and from this piece of legislation, is that you will find under the POCSO, there are more or three offenses we say. One is an assault, sexual assault. Second is an penetrative assault. And the third is, I believe, section 11 speaks of the harassment. So this entire act, in principle, there are 4 or 5 sections, that is 3, 5, 7, 9 and 11. Now the introduction of these sections, or just to read it, the first section is called the offense, sexual offenses, is section 3, that is penetrative sexual assault. Then the section 5 speaks of aggravated penetrative sexual assault. Then the section 5 speaks of the section 7 speaks of a sexual assault. Then section 9 talks about the aggravated sexual assault, and the 11th is called defined as sexual harassment. So there are 4 categories of the offenses which have been defined under the POCSO Act: sexual harassment, penetrative assault, and the sexual harassment, the sexual assault, and the penetrative assault. Now, with this understanding, we'll go back to the section 29. What is presumed under the Act? The presumption is this: where a person is prosecuted for committing or abetting or attempting to commit any offense under section 3, section 5, 7 and section 9 of this Act, the special court shall presume that such person has committed or abetted or attempted to commit the offense, as the case may be, unless contrary is proved. Now, as I said, in the traditional law, the prosecution has to prove the fact. Prosecution has to prove the actual act that we call the actus reus. Once a murder is proved, once the property which has been used or the weapon was brought, or when there is a statement of the accused, or there are the scene panchanama is brought on the record, the prosecution proves that murder had taken place. But that is not sufficient. The prosecution has to prove that he committed the murder with intention and knowledge. So any offense along with the actual commission of an act, he has to prove there was an intention. And both these facts, both these facets in the trial were required to be proved by the prosecution. Now, as against this, you will find the scheme of the POCSO or the scheme of the NDPS Act. Both the things are presumed. Therefore, it says, where a person is prosecuted for committing or attempted to commit any offense under the Act, section 3, 5, 7 and 9. So, moment the offense is registered against one person under section 3, 5, 7 and 9, then there is a presumption that he committed this offense. Well, there could be any presumption. But now, next part of the section, you must read it carefully. We said shall presume that such person has committed the offense as the case may be, unless contrary is proved. So therefore, there is a presumption of commission of an offense, and the entire burden is shifted on the accused. Now this gives completely the theory, as we said, that the person is said to be innocent unless he has been found guilty. Here, if you read the section 29, you will find it is presumed that you have committed the offense unless you prove that you are innocent. Now, in conjunction with this, if you read the section 30, you will find it says the presumption of culpable mental state. I said earlier that any prosecution launch, actual offense is required to be proved by the prosecution beyond reasonable doubt. And at the time, he has to prove that the person who committed the offense had a mental state or the culpable state of mind to commit the offense. It could be a knowledge, it could be an intention or reasonable belief, whatever it could be. But now under the POCSO, see the section 30, how it is being drafted. Presumption of culpable mental state. In any prosecution for any offense under this act which requires culpable mental state, on the part of the accused, the court shall presume the existence of such mental state, but it shall not be a defense for the accused to prove, but it shall be a defense for the accused to prove the fact that he had no such mental state with respect to the act charged as an offense in that prosecution. And the subsection 2 further says what would be the degree of proof for disproving a particular fact. The degree of proof you will find under subsection 2. For the purposes of this section, a fact is said to be proved only when the special court believes it to exist beyond a reasonable doubt, and not merely when it exists, when its existence or established by the preponderance of the probability. Now, therefore, section 29 and 30 are the different in the code itself. Subsection 30 says there is a presumption once the offense is registered against an accused, there will be presumption that it was committed with the culpable state of mind. All right, to this extent one can understand. But so far as subsection 2 is concerned, what is the degree of proof? A degree of proof is not on a preponderance of the probability. It is something more than that, that is a beyond reasonable doubt. Normally you will see under section 106, when the prosecution invokes 106 or 113B in the dowry cases, there are presumptions in the law. No doubt, there are presumptions and such presumptions are required. But to rebut these presumptions, because presumption is not on a proof, presumptions of facts. So the rebuttal of this presumption by the accused, some proof was required to be brought on the record. What was the degree of proof required? Was required under the ordinary enactment or ordinary offenses. That was by the just creating a doubt or by the preponderance of the probabilities. But if you see the subsection 2 of section 30, you will find there is not only a presumption of that you committed the offense, there is a presumption that you committed the offense with the culpable state of mind. And if at all you want to rebut, or the accused has to rebut this presumption, not by just creating the doubt, but he has to rebut that presumption beyond a reasonable doubt. So it travels beyond the theory or a degree we call the preponderance of the probability, shakya ashakyatecha tarkavarti. It's something not that. So once the offense is committed against, or the person is booked, the offense is registered for committing the aggravating sexual assault, he has to prove. How is he going to prove? Whether you have asked yourself, is it possible for an accused to prove a negative fact that he has not committed the offense? What I just want to convey to the audience is this: taking the recourse to these provisions of the POCSO Act, for an example, I don't deny or I do not say that in the socio-economic legislation, certain presumptions are required to be incorporated. The clauses are required to be incorporated. But nevertheless, as per the basic jurisprudence of the criminal law, it is always a duty of the prosecution. A prosecution has to discharge its initial burden, and then only it shifts, the legal burden shifts on the accused, and not otherwise. But the scheme of the POCSO Act, or you will find the scheme of the NDPS Act, section 34 and section 54, you will find there is a presumption of both the counts. If the accused who is found in a possession of some narcotic drugs, then he has to give an account as to from where you brought it, how you came into the possession. If he fails to give the possession, there is a presumption that it was within his conscious knowledge. This was a conscious possession. There was a famous case where one constable or a person was found sitting on a gunny bag containing the narcotic drugs. And since he was found sitting on the gunny bag, the prosecution claimed that he was in the possession thereof. Obviously, he was not able to give the account as to how he came into the possession, or why he could not give it because he was not aware that this bag was containing the drugs. But nevertheless, since he could not deliver or he could not give an account satisfactorily, a presumption was drawn that it was on a conscious possession. So therefore, such provisions which are being now we find under the special enactments, a possibility of misuse. I am not against the legislation wisdom at all. I am much critical on the two aspects. I am critical on the aspect is this: no doubt for the socio-economic legislation it is necessary, or sometimes the prosecution may not have the access to what was the knowledge, or certain things prosecution may not be able to collect it, therefore presumptions are necessary. But nevertheless, whether accused can be asked to discharge the burden by a degree of a proof we call the beyond reasonable doubt. Now, this I find sometimes a disturbing fact. It could be rather impossible for an accused to rebut such presumptions by leading the evidence beyond a reasonable doubt. I can understand, because in most of the cross-examinations we find in the Indian Penal Code offenses, certain suggestions are being given. Once the prosecution examines the witnesses, the certain suggestions are given, and most of the suggestions are this, that what you are implicating is a false implication. There was an enmity between me and the accused, and therefore he has falsely roped in. This is normally the line of cross-examination. So the prosecution or the defense tries to create some sort of a doubt of the prosecution case, and therefore we say that was just by the way of a preponderance of the probabilities. But in this act or under NDPS Act, the accused is heavily burdened with these facts, and how is he going to discharge this? So therefore, a possibility, that is what the apprehension under the special enactment is, that a prosecution or the state, as I said earlier, the law does not become a tool for oppression, remains, or it should not cause an injury to the injustice. There were the enactment prior to the independence. Some enactments are being carried forward even after the independence. But the acts which were enacted by the British era were used for it became a tool of an oppression. It should not become, it should be an instrument of a justice. So therefore, is there any possibility, is there any authentic data available, or we call, unless there is some factual proof is available in the hand, why the legislators have enacted the section like a section 32? There has to be an empirical data available that such and such things, the compelling the prosecution, compelling the parliamentary to shift the burden. Otherwise, you will find nowadays in the society, the special enactments have been largely misused. Those special enactments are being largely misused, the persons or the power who implements or runs the state. I need not comment on this subject. I need not say much on this subject. But today I just want to convey to you that it is a high time, it is a time where there has to be some movement to see that the presumptions of the innocent is not being asked to be rebutted by the accused. Otherwise, it would be the people will start having no faith in the society. People will have no faith in the system at all. Because tomorrow, if a king wants a person to be oppressed by the instrument of law, it becomes very simple to register the offense against him. To register the offense, there will be presumptions. There will be presumption of actus reus. There will be presumption that he has committed the offense. And then you ask that accused, you come and show that you have not committed the offense or there was no intention to commit offense. Whether is it possible to prove a negative fact? Fact is an assertion. Fact is a positive thing. What we need to prove is a positive act and not a negative act. Whatever it could be, but the provisions of section 34 and section 35 of the NDPS Act were challenged, the constitutionality was challenged before the Honorable Supreme Court in the Noor Agha case. In the same arguments were advanced. Their Lordship Justice Agarwal has delivered the judgment in the Noor Agha case, and the two words of caution are sounded. Justice Agarwal in his judgment, well-written judgment, celebrated judgment, said that the parliament or the legislators, when they make act, they have to see that the act strikes the balance between the individual liberty and the public good. As I said, that certain offenses like a 329 or the NDPS Acts has a social economy repercussions. So, accused whose guilt has not been proved, we presume that he is innocent. So that is an individual right. But because of his acts, there are many victims in the society. Then in that case, the act must be, or the legislation must strike the balance between the individual rights and the right of the society. We call the societal interest. So in the judgment of the Noor-Agha, the theory that was canvassed is that when any piece of legislation is enacted or made by the parliament has to keep in the mind that the act of the person will not cause any prejudice to the member of the society. So, the acts which may have larger repercussions in the society, then in that case, the larger interests of the society would prevail on the individual rights. And therefore it said, it is necessary to presume certain facts, and therefore the presumptions under the NDPS Act were held valid and proper. Nevertheless, you will find thereafter number of judgments have been delivered by the Bombay High Court in the case of the POXO and NDPS, where it has been stated that unless a foundational facts are placed or proved by the prosecution, particularly under the POXO Act, unless there are the foundational facts are proved, you cannot draw the inference simply that he has committed the offense. So therefore, the provisions of the section 30 of the POXO Act, which casts or burdens the accused to prove the case beyond reasonable doubt, has been interpreted by this court to see that the rights of the accused are preserved or those are being kept intact. So my appeal to the audience is only this: you have to study how the trend of the legislation is changing nowadays, whether the law has become a tool for oppression or that is being used as an instrument of a justice. You need to evolve this, you need to study this, you need to interpret this. It is not only I am limiting myself to the provisions of the POXO, but I am limiting or I am saying what will be the repercussions, larger repercussions on the society itself. We have a faith. We consider the prosecution and the state as my guardian. They have to guard, they have to protect the interest of every individual citizens of the India. But if the same state, with the tool of such enactments, starts the exploiting the citizen, or there could be a possibility of using these acts as an instrument of oppression, and that time there will be end to the democratic setup. So I appeal to all of you to be alert, see the enactments not by the letter, by the spirit, and I am sure you will certainly appreciate what I have stated. You would certainly welcome my thoughts which I have canvassed before you, but nevertheless I would say these are my personal thoughts, these are my personal views, and I never intend to say or never to say that the enactment enacted by the parliament had failed in their wisdom. Thank you very much.
धन्यवाद साहेब. आपण केलेल्या मार्गदर्शनाचा आम्हाला नक्कीच फायदा होईल. कार्यक्रमाच्या पुढे होताना मी ॲडव्होकेट तेजस दंडकावळ यांना विनंती करतो की आजच्या कार्यक्रमाचे आभार प्रदर्शन करावे.
धन्यवाद चितोळे सर. ज्युडिशियल कलोकिया पुष्प 6वे गुंफण्यासाठी आज आपल्याला मार्गदर्शक म्हणून लाभलेले मुंबई उच्च न्यायालयाचे न्यायाधीश जस्टिस SK शिंदे साहेब यांनी आपल्याला जे अमूल्य मार्गदर्शन केलं त्याबद्दल त्यांचे आभार. त्याच पद्धतीने KP नांदेडकर साहेब यांचे खरं तर मनापासून ते उपस्थित असल्याबद्दल तर आभार आहेच, पण आपलं जे सेकंड होम आहे अशोका हॉल त्यांनी रिन्युएट करण्यासाठी म्हणून जी मेहनत घेतली आहे त्याबद्दल त्यांचे परत एकदा अभिनंदन करतो, आभार मानतो. त्याच पद्धतीने आपण सर्व ज्येष्ठ विधिज्ञ, सर्व वकील बंधू भगिनी यांनी या कार्यक्रमाला उपस्थित राहिलेत, या कार्यक्रमाची शोभा वाढवली, त्याबद्दल आपले सुद्धा आभार. आणि असोसिएशनच्या वतीने कार्यक्रम संपला असे जाहीर करतो व चहा पाण्याची व्यवस्था बाहेर केलेली आहे, त्यांनी त्याचा सगळ्यांनी आस्वाद घ्यावा ही विनंती.